Sorry, I hadn't appreciated the clock in this courtroom is 5 minutes fast, but I'm now being told about that, so I won't make the same mistake again.
My Lord, I won't be much longer. I just a few points, and I'll begin with that point, my Lord, that my Lord raised before lunchtime. If one goes to the scheme, I'm not promising that this is the answer, but so it's at page 70 of the authorities bundle, tab 3. Paragraph 114 obviously gives the claims officer the ability to, gives the discretion to, doesn't say that they must reopen an application. If it were to use, if it did say a claims officer must reopen an application, then that would then cause potential inconsistency with paragraph 116, that then says an application may only be reopened under paragraph 114. Now, it may not give rise to an inconsistency because you may then interpret paragraph 116 in line with paragraph 114 to say that the must within paragraph 114 must be interpreted to only be must when paragraph 116 applies. But using the word may, at least retains and clearly retains the discretion and prevents there being an inconsistency. Now, the other, just while I am there, something that I need to stress they refer in their skeleton, LXR refers from their skeleton is paragraph 116, that obviously limits the ability of the claims officer, even if there is a, even if the conditions in section 115 A and B apply, then it need not be reopened where if more than 2 years have passed, the supporting evidence with the application, it means the application can't be determined without further extensive inquiries. Now, just in terms of that point, obviously paragraph 116 doesn't prevent, is not any barrier to any person reopening a claim within 2 years. And so if the claimant's definition, for example, were right, so that it could include a case where there is a change in evidence about cause of the condition, then section 116 would not prevent a claimant coming back within 2 years and providing new evidence, and we say that's contrary to the scheme. That would require the CICA to re-examine an application and consider whether the new evidence meant that the previous decision in light of the old evidence was wrong. We say that can't be right. But even if more than 2 years have elapsed, then firstly, administratively, the CICA would still need to consider it, and so they would still need to determine applications which had closed, and potentially applications that had closed many, many years in the past. And of course, then if there were evidence, they would then have to make a decision on the basis of the evidence provided as to whether further extensive inquiries were required. And there is a difficulty with that expression because it's not clear what extensive inquiries means. There is obviously, it's not sufficient that further inquiries are required. They have to be further extensive inquiries. And so, you know, as a matter of practice, that doesn't, in fact, prevent many claims being reopened, because if a person provides a new report setting out a new diagnosis, for example, in terms of a condition, then the CICA have that new evidence. They have to determine the evidence, but then if they accept that evidence, the question is, well, actually, what other inquiries are there to be made? There may be some, but to say extensive is difficult. So the short point is that although paragraph 116 is a limit on reopening claims, it is no limit whatsoever in terms of claims that are new claims that are brought within 2 years. But in any event, it doesn't prevent sort of the administrative difficulty and potential financial implications of position if claims could be opened on the basis of wide definition put forward by the claimant in the Upper Tribunal. Now, linked to that point is just linked to the point my Lord raised about whether a 115 whether a claims officer would ever refuse to reopen a claim if there was an injustice. The answer, take instructions, the answer is probably no.
There's possibly a Padfield point there, because that might thwart the policy in 114.
Yes, so
For example, if someone dies and there's a different sort of level of compensation payable altogether and direct attribution is satisfied, if someone refused for no good reason which was inconsistent with the statutory scheme, that might be open to challenge.
absolutely. So we can't think of one. An example where it might arise, but in reality, this is probably just a function of section paragraph 115B, is a situation such as that in the case of Jones, which is at tab 42 of the authorities bundle, which was a case involving an application to reopen where the CICA refused the application, A, because there was no material change in condition, but B, also because the applicant's victim's subsequent criminal record meant that it wasn't just to make an award in any event. And the Court of Appeal essentially said the relevant part is paragraph 27 of tab 42. So it's tab 42, which is in bundle 2, and paragraph 27. Now, this was dealing with paragraph 56 of the, I think, the 1996 scheme. So it's a slightly different, paragraph 56 is set out for reference at paragraph paragraph 2 of the judgment at 1202. So it's very similar in the sense it says the claims officer may, however, subsequently reopen a case where there's been such material change in the victim's medical condition that it would be an injustice. And what the Court of Appeal says at paragraph 4 is a matter of construction. The purpose is to prevent injustice, so it does not compel the reopening of a decision where the maintenance of the original decision would not create an injustice. In order to reopen a case, an officer must be satisfied if the original assessment were allowed to stand, there would be an injustice, and that injustice would be caused by changing the applicant's medical condition.
Yeah.
So now, and then if one looks at paragraph 27, the Court of Appeal says the correct questions for the decision maker are: would there be an injustice if the earlier decision remained in place, and would that injustice be the result of a change in the applicant's medical condition? So, applying paragraph 114, what we say, well, the first question is there an injustice if we reopen it? And if the reality is we would not make an award, or the First-tier Tribunal would not make an award in any event, we don't need to go any further. So that would
Yeah, because 115 isn't satisfying.
then the one other point was made just by reference to, I had to make by reference to the claimant's skeleton. It's a point I should have raised. If one goes to the claimant's skeleton, or at, so this is paragraph 21 at C24. Behind tab 6. And dealing with their response to grounds of appeal, I think I've dealt with everything I need to, but just one point in terms of the way the case was put below. Paragraph 21. They argue that our argument mischaracterised the findings of the FTT and the nature of the case before the Upper Tribunal. They say the claimant accepted that he could not disturb the requisite rationality standard on claim for judicial review. The FTT's finding that there had been no material change in the medical condition as defined by the FTT, which on a fair reading of its judgment only related to changes in symptomology. So they then go on to say there's no sort of wider concession made. But that, in my understanding, remains the claimant's position, that he could not disturb and was not seeking to disturb to the requisite rationality standard of a claim for judicial review the findings that there had been no material change in clinical condition as defined by symptomology, and we say on a fair and objective reading of the scheme that is in essence an end of the matter. And then one final point on the question of diagnosis. Again, I don't know the extent to which this in reality rises, but it's a point I should perhaps have mentioned, is that I mean, the difficulty with diagnosis and whether diagnosis can be a material change in condition. What happened in this case is that Dr. Yankoff said there was PTSD. Dr. Scott said the predominant presentation was personality disorder, but also PTSD. Now, after the claim, after the first-tier tribunal decision and to support their grounds of judicial review, the claimant filed and sought to rely on the claim, the report of Dr. Green, and that is at the supplemental bundle, part is 272. And supplemental bundle.
This is post the FTT, isn't it?
Yes.
Sorry, where is the supplementary bundle?
Sorry, it's page 272. Yeah, so it begins at 257. It's quite a long report, and the relevant part is at 272. As one could see at Dr. Green's view is that what one can see at the bottom of 274. She says, with reference to Dr. Law's assessment, this is at E14E, in her letter to CICA that the change in Mr. X's understanding of the cause of his symptoms as a change in cognitive condition is in my view as follows. So she's setting out what her view. The diagnosis of Mr. X's post-traumatic stress disorder has not changed, and this condition has been ongoing since 1997. She says then at F, at page 275, F1, in her view, there was no change in Mr. X's psychiatric diagnosis of a post-traumatic stress disorder in this time. And at F3, she then says, this psychiatrist is satisfied that Mr. LXR can be she is no longer satisfied that Mr. LXR can be diagnosed as suffering from an emotionally unstable personality disorder, and he now probably meets the change for the criteria for persistent depressive disorder. So what happens is that we have one expert in 2017 that says PTSD. We have another expert in 2019 that says personality disorder and PTSD. We have the tribunal in its findings that says it's PTSD. And then we have a subsequent report that says PTSD with depressive symptoms.
What's the status of this report?
So the judge properly did not. There was an application to rely on it, and it's not. There was a mention of it, but my understanding is that the judge didn't accept.
If this is a JR challenge, then you look at the material that was before the decision maker.
Absolutely, and that's what the position we made. What the claimants were saying was, insofar as their human rights challenge was concerned, they were entitled to rely on new evidence.
I was just going to ask, I may have missed it, are we given the instructions of this expert? The questions he was answering? I mean, it's alluded to on 258 at item 1, letters of instruction. But for example, was this in the context of the material change test?
We don't have the instructions. We opposed the we certainly oppose reliance on it insofar as the claim was a judicial review, because we said we made submissions before the Upper Tribunal that the decision of the Upper Tribunal has to be, of the First-tier Tribunal, has to be determined by reference to the material before. You can't introduce material later. And that is my understanding of the approach that the judge took in respect of what he dealt with. But the point I simply want to make is, if there are real difficulties if one is going to allow claims to be reopened based on new evidence, because different psychiatrists, different medical experts will disagree, and here you can see a sort of a changing, a different. Whether individual experts' views have changed, we don't know, but we certainly see different experts with different opinions. My Lord, I think those are all matters I need to deal with. Obviously, the human rights argument I will deal with in reply to my learned friend.
Yeah. Yes. Yes, Mr. Butler.
Can I please begin by addressing the matters in the appellant's notice, and then after that in the alternative dealing with the respondent's notice argument?
Yes.
If I could just give an indication of where I'm heading with my argument. Where I'm going to end up is an attack on the First-tier Tribunal's direction as to the meaning of medical condition, which one sees, as my Lord Justice Singh suggested, in the last 4 lines of paragraph 19 of the First-tier Tribunal's decision. The correct approach, we say, is set out by the Upper Tribunal at paragraph 33, last 4 lines. What I'm seeking to do is to defend the Upper Tribunal's conclusion. I'm not seeking to defend the case that I advanced before the Upper Tribunal. And my submission is that
That is the reasonably ascertainable point.
I'm not seeking to defend that approach.
But when we come to Article 14, are those the words you're suggesting should be read into the statute?
No, I'm going to suggest that one approaches it in the way that the Upper Tribunal did.
Because that's not the way I understood it.
No,
so far.
and I'm
So
sorry
there's-
that it's not
there's-
being
there's-
clearly put.
There's a change there, okay.
Where one ends up in my submission is that one shouldn't gloss medical condition to limit it to symptoms or to limit it to anything else. And in my submission, the First-tier Tribunal was wrong to do so.
Well, if you're not glossing it, to use your word, how do you ascertain what it means? Is it then a question of fact, what it means? That there's just 2 ordinary English words?
I will, if I may, come on to the detail of my submission in due course. In its broadest sense, it can be read as the state of health of the individual. If one is going to narrow it so as to refer to a particular diagnosis, then it is the characteristics that are related to that diagnosis. Characteristics that are related to that diagnosis. I'll explain what I mean by that, if I may, in due course. To give the court the proposed structure of my submissions, 4 topics. First, to say something about the medical evidence. Second, my submissions on the proper interpretation of paragraph 115 of the scheme. Third, to say a little more about what we identify as the error in the First-tier Tribunal's decision. And then fourth, I can deal quite quickly with the grounds of appeal.
Yes.
So topic 1, the medical evidence. I propose to make 3 points under this topic. 1, LXR's diagnosis. 2, the change in LXR's understanding. and 3, the significance of a change in understanding of a medical condition. So first point, diagnosis. I was proposing to take this by reference to Dr. Green's report. I've heard what the court's just said about it, but it's the same diagnosis throughout. But what Dr. Green helpfully does is he identifies where one finds the diagnosis in the DSM, which I wanted to turn to next. So if I could just show the court where one finds the diagnosis. This is in the supplementary bundle, page 257, which I think is the start of that report, and within that is page 272. Which is roughly where my learned friend left off. And one sees at paragraph 1 on page 272 that the primary diagnosis is chronic post-traumatic stress disorder, satisfying the criteria for the diagnosis in DSM-5. And Dr. Scott gives the same diagnosis. Could I please then show the court the diagnostic criteria from the DSM, which is the additional tab 66 that we sent through on Monday. This is end of volume 3 of the authorities. So page 2057, one sees the diagnostic criteria and one has to satisfy each of sections A through to H. And what I wanted to emphasise is section B, that the diagnosis requires certain symptoms, and relevant symptoms involve unpleasant emotional reactions to memories, dreams, flashbacks of the traumatic event, or to things that resemble the traumatic event. And I make 4 observations about that. The first is that PTSD is different from, for example, a broken leg, because a broken leg is a broken leg, regardless of its cause. By contrast, there is no PTSD unless one's identified the traumatic cause. Second, for the purposes of paragraph B1, the recurrent involuntary and intrusive distressing memories of, say, a traumatic road traffic accident will be different from recurrent involuntary and intrusive distressing memories of, say, a traumatic assault, even if the severity of the distress reaction is identical in each case. Third, there's liable to be a relationship between the nature of the intrusive memories and a victim's understanding of his condition. If the intrusive memories are of an assault, the victim is liable to understand that the assault is the cause of the medical condition. My 4th point on this, if we could please look at page 2062, which is part of the explanatory text on the criteria. At the bottom of page 2062, there's a heading, Development and Course, if the court wouldn't mind just reading that short paragraph. And so I make the observation that the manual recognises the possibility of delayed onset. That's what I want to show the court on the diagnostic manual. My second point under topic 1 is to look at LXR's understanding of his condition at the time that CICA made its award and the change in LXR's understanding since then. Now, what I propose to do is to focus on the evidence that was accepted by the First-tier Tribunal. Both sides are stuck with the First-tier Tribunal's findings of fact, given that neither side judicially reviewed those findings of fact, and CICA didn't advance a section 31(2) capital A argument in the Upper Tribunal and haven't advanced a ground of appeal based on 31(2)A. So we're stuck with the First-tier Tribunal's findings of fact. Could we please turn up the Tribunal's decision? This is in the core bundle at page 251. The court's already looked at this a number of times. Within that decision, could we look please at page 252? So the court will see at the bottom of page 252, there's a heading, findings of fact. And then overleaf at paragraph 11, one gets a first finding. A finding of fact that LXR's treatment led to a change in his understanding of his condition and its origins. And then if we could look forward please to page 255. At paragraph 25, the First-tier Tribunal rejected Dr. Law's evidence on the change in severity of his symptoms. So I'm not going to focus on the evidence of change in severity of symptoms because that was rejected by the First-tier Tribunal. Instead, I'm going to focus on the evidence that led the First-tier Tribunal to conclude, as it did at paragraph 11, that there was a change in understanding of the condition and its origins. Now, CICA made its award of £11,000 for the physical injury of LXR being raped as a child, and it made that award on the 15th of August 2019. And so I propose to look at the difference in LXR's understanding of his condition before and after that date. In August 2019, CICA relied on the evidence of Dr. Yankov. The court's already been shown Dr. Yankov's report, but could I please focus on two paragraphs that you haven't looked at yet? This is in the supplementary bundle. The report begins at page 85. The bit I'm interested in is at page 97. So page 97, paragraph 4.6, Dr. Yankov said it's important to note that LXR's current presentation doesn't make references to reliving the trauma of his childhood abuse, but is very explicit that he experiences flashbacks, nightmares and avoidance in the context of his encounter with Padre.
The encounter with Padre was a series of discussions about what had happened in the 60s. Sorry, not the 60s, when he was 6 to 10.
The 80s. Yeah. Yes. Can I show the court what those flashbacks were, as described by Dr. Yankov, page 92. Paragraph paragraph 3.42, we see the detail. LXR told me that ever since the meeting with the vicar, I keep seeing him and I can smell the church. He added, if I close my eyes, I see him. When I try to sleep, he comes in my head. Those are the flashbacks. In August 2019, CICA also relied on the correspondence from the psychotherapist, Joanne Ruby. Again, you've already seen this letter, but could I identify a different paragraph of it? Page 113, same bundle. Halfway down that page, Ms. Ruby described LXR symptoms. There's a second bullet beginning, you daily experience. If the court would please read that bullet point. And CICA reached its decision in light of that evidence of Dr. Yankov and Ms. Ruby, and one sees that same bundle, page 116. This is the reasoning of CICA's decision on the 15th of August 2019. And the penultimate paragraph begins, your medical records.
Yeah.
You could please just reread that one paragraph. So that was the decision of the 15th of August 2019. On the 23rd of August 2019, so a week after CICA's decision, LXR began weekly therapeutic treatment with Dr. Law. The reference to the date of that, I don't need to turn it up, I think, but the reference is supplementary bundle, page 119. So treatment commences 23rd of August 2019. On the 20th of December 2019, so that's 4 months after treatment commences with Dr. Law, Dr. Scott produces her report. As the court has seen, that begins in the supplementary bundle at page 121. The bit I'm interested in is at page 170.
Sorry, give me the page again.
170.
11170.
170. And so on that page, the court should see a heading on the left, causality. And could I ask the court please to read 2 paragraphs of this, paragraph 342 and paragraph 345 on the following page.
Maybe also 343.
Yes.
And also 344.
Yes. what I wanted to emphasise was paragraph 342, where Dr. Scott concluded that there had been a transfer of psychiatric symptoms from the child abuse to the padre. Third line from the end, she uses the expression transferred and solely attributed. So that's 4 months after treatment has commenced with Dr. Law. After 2 years of treatment with Dr. Law then writes to CICA. And that's the letter at same bundle, page 204. This is the letter dated the 23rd of August, 2021. And if we could begin, please, with the conclusions of page 206. She describes 2 changes in LXR's medical condition. The first is a change in his understanding of his condition. The second is an increase in the severity of his symptoms. Now, as we've seen, the First-tier Tribunal accepted the first conclusion was correct, change in understanding, but it rejected the second conclusion, change in severity of symptoms. As I said, I don't challenge the Tribunal's findings of fact so far as they go, so I'm going to focus on what Dr. Law said about change in understanding. If we go back, please, to page 204. The last paragraph on page 204 begins when LXR first began his work with me. And if you could please look at that through to the middle of the following page. This is where Dr. Law explains the significance of the change in understanding. And then on the second,
At the end of that passage, the next paragraph, it leads to these changes have led to a significant deterioration.
yes, and
At
that's
that point you're not pursuing.
that's what I'm not pursuing.
So you're pursuing this point, falling short of that.
Exactly so. That's what I submit is open to me in light of the Tribunal's findings of fact. Could I make 3 points about the passage that the court has just read? The first point, last line on page 204. LXR's understanding was relevant because it affected his presentation. Second point, first line on page 205. LXR's understanding was also relevant because it affected the treatability of his condition, ability to address and treat his condition, which I paraphrase as treatability.
Lost that.
So on the first line of page 205, which begins,
Yes,
and
I beg your
ability
pardon,
to
I'm
address
sorry.
and treat his
It's
condition.
my fault, sorry.
And so I say that my second point is that LXR's understanding was also relevant because it affected the treatability of his condition. And that's not just about a change in symptoms.
Is anything more said about that? That's as far as it goes.
That's as far as the treatability point goes in this letter from Dr. Law. Third point, the second full paragraph on page 205, so the one which begins since LXR and I have been working together, one sees the explanation that the change in understanding resulted from the long-term therapy provided by Dr. Laws.
Sorry, where are you?
I'm paraphrasing the second paragraph on page 205.
Oh, I see.
And again, this is my paraphrase, but using the terminology of Dr. Laws, LXR's mind had previously blocked off the experience of child abuse to protect LXR from painful emotions. Treatment had resulted in the unblocking of that trauma. She uses the expressions block out and reconnect. So that, in my submission, is the evidence of change that was accepted by the First-tier Tribunal. My third point under topic 1 is to look at what Dr. Green says about the significance of a victim's understanding. Now, of course, I don't rely on Dr. Green's report to impugn what the First-tier Tribunal decided. I couldn't because it wasn't before them. But it provides a useful explanation of how, in principle, a change in understanding is relevant to medical conditions. So if we could look, please, in the supplementary bundle at page 274. And I'm sorry we don't have the letter of instruction. I can ask that that be provided to the court if you would like to see it. I'm afraid I don't have a copy. I don't know what it says. Page 274, paragraph 14. Could I please ask the court to read paragraphs A through to D, to the end of D? The whole of paragraph 14 is of value, but I, in the time available, wanted to ask the court to focus on A to D.
Well, D is drawing distinction between PTSD and something which has more than one cause. I mean, what you've shown us so far relates to PTSD, not what is sometimes referred to as complex PTSD. Have I understood correctly so far?
What I showed the court in relation to the diagnostic manual was
PTSD. Yeah.
What, in my submission, Dr. Green is doing is talking primarily about PTSD, but then it merges into complex PTSD.
Letter C, this page seems to be referring to symptoms.
Yes.
But you're not relying on that.
Well, it depends what one means by symptoms. In the sense used by the First-tier Tribunal, they're talking about symptoms of the kind that are described in the diagnostic manual of nightmares, emotional responses and so forth. I understand Dr. Green to be talking about something slightly different, which is insights. And in my submission, the first-tier tribunal, when they're talking about symptoms, don't seem to have insight in mind as coming within the parameters of symptoms.
Right. The other thing that the same paragraph, and indeed A and D refer to, is causality
Yes,
or etiology,
yes,
which may be the same thing.
yes.
And you say that that is, in principle, capable of coming within the concept of medical condition.
Yes, I do. Because, well, I can't want to make my submissions about the structure of the skin in due course. But I do respectfully say, notwithstanding the use of the word symptoms in paragraph C, that it's relevant that the presence or absence of insight can be characterised as part of a condition. Plus the causality point that my lord identifies. Could I also ask the court please to look at paragraph E, Roman 4. So it's my opinion that the person's understanding of their condition in that paragraph. So here Dr. Green's using insight and understanding as relevant to therapy and recovery, rather than as a symptom per se. And that chimes with what Dr. Law said, albeit I accept that this is post hoc material.
It seems to be saying that the treatment is helping to overcome the repression, which you refer to, and there seems to be potentially a positive note at the end of Roman 4, recovery.
Yes, well, I can see an argument that this is puts one on the pathway to an improvement in medical condition. But one of the submissions I'm going to make in due course is that paragraph 115 of the scheme doesn't rule out improvements if, as a consequence, justice calls for a change in the award.
Yes, but I was going to ask this question. This line of evidence you're asking us to look at on the basis that you don't challenge the findings that he wasn't getting worse. So was this put to the tribunal, FTT, to assess on the basis that they should consider a material change and injustice in the context of a condition which wasn't getting worse?
Well, the court has already seen, because my learned friend showed you, the way in which it was argued before the first-tier tribunal, and you'll recall that there were 3 strands to the argument, one of which was a deterioration in symptoms. Well, we lost on that. One of the other strands was change in understanding.
Yes, but
And that was accepted. And the evidence, the only evidence that can have been accepted on change of understanding in my submission is the explanation that was given by Dr. Law that was before the
But the
tribunal.
argument surely was that the change in understanding was itself causative of a deterioration in the symptoms.
Well, that was one element of it, because we see that in Dr. Law's letter. She
you
says,
might need to look at Dr. Law's letter again, because she does point to the result of that change in...
so back to page 204.
Supplementary bundle.
Supplementary bundle, yes.
My fault, sorry.
And that's why I began at page 206 by identifying the conclusion that there were 2 aspects of the material change. One aspect is change in understanding. The other aspect is in change in symptomology.
Yeah.
And then the letter is divided up into 2 halves. 204 to the middle of 205, which is focused on change in understanding, not change in symptomology. And then the second half of page 205, which is dealing with symptomology. Now, I appreciate that Dr. Law says that the reason one gets a deterioration in symptomology is because or is connected to the change in understanding. But she is making two discrete points. And in my submission, the first-tier tribunal is making a finding to accept one, but to reject the other.
But my question is, there are two different cases, aren't they? One is related to the condition getting worse, deteriorating, and this way you're putting it doesn't depend upon that.
Yes, that's
That's therefore consistent with either the situation remaining much the same in terms of severity of disability,
yes,
or actually improving.
yes.
Now, if it was an improvement case, would you expect someone to be asking for a further award of compensation?
Potentially, yes, and I'll show the court why.
But would it, forgive me, it sounds like a specialist, that's quite a special situation.
Yes, it
You
is.
would expect the advocate presenting the case to make it clear that's what they were asking the tribunal to think about.
Well, I don't have a record of how the argument was put orally. It wasn't me. I don't have a record of how the argument was put orally before the first-tier tribunal.
It's a slightly subtle point. You would therefore expect it to be articulated explicitly.
I don't. Yes. If I was presenting it with the benefit of hindsight, I would emphasise that point. Whether it was put in that way, I'm afraid I just don't know. All I can show this court is the record of the written argument, which you've already seen.
Can I just ask you another point about this letter? You focused on what you call treatability of the condition. Is treatability of the condition itself part of the condition?
In my submission, within the meaning of paragraph 115, yes.
So if a new drug comes on the market which can ameliorate symptoms, that is part of the condition itself.
That would satisfy the bit of paragraph 115 that talks about change in medical condition, yes. Would it lead to a reopening of the award? No, because there wouldn't be so material a change that made it unjust to maintain the original award. Could I just make one more point in relation to this third point under my first topic? Where I had left off was Dr. Green and the explanation of paragraph 14 of her report. The Criminal Injures Compensation Authority itself recognises that there may be delay in the unblocking of trauma in cases of child abuse. And can I just show the court that? If we look first at the scheme rules, so this is the Authorities Bundle, tab 3. At page 64. At paragraph 88 of the scheme, one sees the ordinary limitation period for crimes of violence suffered by children. And the ordinary limitation date is 20th birthday or 2 years from the date of first report to the police. Then if we turn over leaf to page 65, one sees paragraph 89, and in particular 89A, that period that we've just looked at can be extended if, due to exceptional circumstances, the applicant couldn't have applied earlier. So this is the originating application in the case of child abuse. Could I then please show the court CICA's guidance on that paragraph, on paragraph 89A? This is in the Authorities Bundle at volume 3, tab 65. And one sees from the cover sheet that this is CICA's internal guidance to the 2012 scheme. And if we could look,
It's
please.
internal, but has it been in fact published? Obviously, you've got it.
I think it must have been that we've got it.
And sometimes that can matter, as you know, in the immigration case, there have sometimes been secret draw policies.
Yes, I don't think this is a secret draw policy. Page 2016. Provides some commentary on paragraph 89A of the scheme. And it's just one short bit that I want to draw attention to. After the bullet points, there's a paragraph that begins, exceptional circumstances more likely to exist in cases involving sexual abuse, especially where the applicant is a child at the time of the offence. This is because the silence of the victim and ongoing psychological and emotional trauma are well known to be direct consequences of such crimes. These effects continue into adulthood. So that recognises, in my submission, the possibility of delayed impact of child abuse, albeit the internal guidance doesn't descend into the psychological reasons for the delay, such as blocked trauma or the transference of trauma. But that must be the underlying rationale for that provision, or that piece of the guidance. So those are my submissions on topic 1, the medical evidence. Could I then please turn to the scheme? So back please to volume 1 of the authorities, tab 3. Paragraph 115 is at page 71. And so the provision, as the court knows, the provision in issue in this case is that there has been so material a change in the medical condition of the applicant that allowing the original determination to stand would give rise to an injustice to the applicant. It's a composite expression. So can I begin, please, by considering the meaning of medical condition of the applicant before examining the meaning of change and then materiality. I propose to make 6 short submissions on the medical condition of the applicant. First submission is that medical condition of the applicant is a broad and undefined expression. The drafters of the scheme could have given it a defined, narrower meaning, but they didn't. My second point is that if one uses the expression medical condition in relation to a particular diagnosis, then there's a difference between the narrow diagnostic label and the characteristics associated with the medical condition. So, for example, the difference between the diagnostic label of PTSD and the characteristics associated with the PTSD that the applicant has. Even the First-tier Tribunal didn't take medical condition to refer only to the diagnostic label. The FTT accepted that an increase in the severity of symptoms, that characteristic of medical condition, would be capable of constituting a material change, even if the diagnostic label hadn't changed. Now, a particular medical condition, particular diagnosis, may have a range of characteristics beyond symptomology in my submission. As the Upper Tribunal observed, one might describe a medical condition in terms of its etiology, its symptoms, the degree of disablement, the prognosis, or the condition's treatability. Which characteristics are relevant to describe a particular medical condition is liable to vary from case to case. For example, as I submitted earlier, in the case of a broken leg, understanding the cause of the injury may have little relevance. By contrast, with PTSD, the relationship between the traumatic event and the symptoms is relevant. It's one of the diagnostic criteria. Now, as the court will have seen, Annex E to the Criminal Injuries Compensation Scheme covers a wide range of injuries and medical conditions. And it therefore made sense in my submission for paragraph 115 of the scheme to take a broad and flexible approach to the concept of medical condition of the applicant that was capable of applying in all circumstances covered by the scheme. Now, third, one can go further than that and say that medical condition of the applicant needn't refer to a specific injury or disease at all. The medical condition of the applicant could be taken simply to refer to the state of health of the applicant, without the need to refer to a specific diagnosis. Now, as I'll submit in a moment, one needs to relate the medical condition of the applicant to the injury table in the scheme, but that's as a result of the words, so material that allowing the original award to stand would give rise to injustice. If one takes the expression medical condition of the applicant on its own, it can, in my submission, naturally be read as simply referring to the applicant's state of health.
So, for example, someone who is perfectly healthy, you can sensibly, as a matter of the English language, ask what is that applicant's medical condition?
Precisely.
They don't have any
No.
illness or injury at all.
If I go for a medical examination for the purposes of health insurance, the doctor may say, well, your blood pressure is a bit high, your cholesterol should be a bit lower. That's a description of my medical condition, but there's no diagnosed disease.
But this scheme is in the context of injury.
Yes, and as I've submitted, one has to relate it to the injury table for the purposes of paragraph 115. But in my submission, that's a function of the words so material that it would be unjust not to reopen the award, not as a function of the words change in medical condition.
Well, but on the examples you've just been given, why should it make any difference to your insurance assessment if the reason that your blood pressure is high is because you're appearing in the Court of Appeal or because you've been, I don't know, drinking too much? Why should that? Why does that make a difference to your state of health?
Well, it doesn't.
The people who are examining you for insurance purposes are just looking at what you are, not why you are.
Yes, and that's my submission, that if one isolates the words medical condition of the applicant, that's all one's looking at. It's the other bits of paragraph 115 that are doing the work.
But that seems to be against your proposition that the cause of the presentation is relevant.
I'm going to explain in a moment why in my submission the change in the medical condition in this case, change in understanding, ought to give rise to a higher award. I'll do that in a moment if I may. taking my points in the order I was proposing, my fourth point on this is that the broad and flexible meaning of medical condition doesn't create a floodgates problem because it's subject to the controls found in the other words of paragraph 115. The change in the medical condition of the applicant has to be so material that allowing the original determination to stand would give rise to injustice. And those are the limiting conditions in my submission. Fifth, if at this point I could please turn up the Upper Tribunal's judgments. This is in the core bundle at page 139. Paragraphs 29 and 30, in my submission, the Upper Tribunal was right to say that medical condition has a broad and flexible meaning. Paragraph 31, in my submission, the Upper Tribunal was right to refer to the role played by the words material, change, and injustice. And then overleaf, paragraph 33, last 4 lines, if I've understood Dr. Law's evidence correctly. In my submission, the Upper Tribunal was right about that.
Do you say that the Upper Tribunal is there using the phrase medical condition of the applicant in the sense that you have submitted to us, namely, it just means the state of health of the applicant?
Well, I'm not sure the Upper Tribunal has gone quite that far. The court will recall I made 2 submissions. One was that there are a range of characteristics of diagnosed conditions. That, I think, is probably the way in which the Upper Tribunal is using the expression, but that's good enough for my purposes. I was going a step beyond that and making the further submission that it could be taken as even broader than that. My 6th and final point about medical condition is that it's appropriate to recognise the special role of the Upper Tribunal in interpreting expressions of that kind. And to make this point, if we could please turn up Authority Volume 1, tab 25, which is the Supreme Court's decision in Jones.
Sorry, which tab is it?
Tab 25. This case concerned the meaning of crime of violence in the Criminal Injuries Compensation Scheme. And if we could look, please, at page 695. This is part of the judgment of Lord Carnworth. And if I could ask the court, please, to read paragraphs 41 and 42. And there's then the point is further developed at the bottom of page 696. Just to put that into context, Lord Carnworth, paragraph 46, is referring to an article that he wrote at a time when he was senior president of tribunals. And overleaf on page 697, he cites from that article, and the citation begins by referring to the approach of appellate courts on appeals from fact-finding tribunals. But then just above letter C, he poses the question, but what if there is an intermediate appeal on law only to a specialist appellate tribunal? And if the court could please read to the end of that citation.
Just to be clear, where it refers to the Social Security Commissions, that was the equivalent of the Upper Tribunal in the pre-2007 era.
That's my understanding.
Yeah, well, I remember appearing in front of them. That's what they were.
Right. And so my submission is that if there's a range of plausible interpretations of medical conditions, but obviously if it's only got one proper meaning and the Upper Tribunal got it wrong, well, that's the end of the matter. This court will overrule the Upper Tribunal. But in my submission, if there's a range of plausible interpretations of medical conditions in this scheme, then it's appropriate to give some leeway to the Upper Tribunal's interpretation of the expression because of its special role in giving guidance on the meaning of the scheme.
And that is a leeway not given to the FTT.
In my submission, yes, because the role of the appellate tribunal is on giving guidance on the law.
And ensuring consistency at the first-tier level.
Exactly.
Which is one of the points Lord Carnworth makes.
Yes. So the first-tier tribunal gets leeway on findings of fact. The Upper Tribunal gets leeway on interpreting the scheme as a matter of law, in my submission.
Yes.
So those are my submissions on the meaning of medical condition. Could I then please turn to the word change, which one sees in paragraph 115 of the scheme? 2 points, if I may, on that. First, it's obvious in my submission, as the Court of Appeal identified in the case of Williams that we looked at earlier, that the word change requires a comparison between the medical condition of the applicant at the time of the original award and the medical condition of the applicant at the time of the request for reopening. Don't propose to turn it up unless you want me to, but that's effectively what the Court of Appeal said in Williams, page 308, paragraph 26. My second point on change is that paragraph 115 doesn't restrict itself to any particular type of change in the medical condition of the applicant. Rather, in my submission, it's the words "so material" and "give rise to injustice" that limit the kinds of change that will be relevant. Could I then please turn to the word material? 3 points, if I may, about that. First, to what thing does the change of medical condition of the applicant have to be material? And the answer in my submission is that the thing to which the change of medical condition of the applicant has to be material is to whether allowing the original determination to stand would be unjust. Second, we say that the Upper Tribunal was correct to say that whether a change would render it unjust to maintain an award is liable to depend on whether, in light of the change, the individual would be eligible for a higher award. Just for the court to note, that's paragraph 27 of the Upper Tribunal's decision. In most cases, that will only be so if there's been a worsening of symptomology or prognosis. But that won't always be the case, to come back to the submission that I trailed earlier. And to illustrate that point, could I please ask the court to look at Annex E to the scheme? So this is volume 1 of the authorities, tab 3. If we could look, please, at page 112. One sees towards the top of that page, there is a heading, sexual offences where the victim is a child. And the last paragraph on that page begins non-consensual penile penetration. And one sees below that an award, B9, which provides for £11,000 in compensation for the physical injury of a single rape. And that's the award that CICA made to LXR in August 2019.
You said physical. Where do I see that word?
One doesn't see that word, but that in my submission is what it is. It's the only explanation for the award for that incident, because the scheme is split into physical and
B12 goes on to deal with mental.
I'm going to come on to that if I may in a moment. At the moment, I'm dealing with the award that was made in August 2019, and in my submission, the compensation that one gets for that one incident is explained as physical injury. I appreciate it doesn't say that, my lord.
So are you saying that when they made the award in 2019, they did not give a single penny for any non-physical consequences that there were for this child victim of sexual abuse?
Well, save insofar as its mental impact that isn't separately provided for by the scheme and doesn't constitute a psychiatric condition.
You may be right, but I just find that surprising.
Well,
anyone who's tried a sexual offences case or sat on appeal from one will know that there is inherent in the violation that people feel, not just the physical injuries, but the mental ones.
I think my lord's probably right. I think probably that there has to be wrapped into this award.
Maybe why the tariff is as it is.
Yes, I think I would respectfully accept the proposition that my lord's just put to me. But can I draw then a distinction between that injury, the B9 injury, and the award that one sees that my lord's already referred to, at the top of page 113, which is award B12. So if the rape caused permanently disabling moderate mental illness, then the award increases to £22,000.
And it can be higher still for severe mental illness.
I'm putting it as modestly as I need to. I'm of course not seeking to limit the case that might ultimately be put elsewhere. If the 2019 award were reopened in this case, then it's reasonably clear in my submission that LXR would receive at least £22,000 because the expert evidence is that the child rape resulted in mental illness and there's a psychiatric prognosis that this is permanently disabling. That's what Dr. Scott says.
Reopening would include the causation point.
Reopening
Previously decided the other way.
when my lord says previously decided the other way in the August 2019 awards. Yes. But not because, not on the grounds that the doctors at the time got it wrong, but on the grounds that there's been a change in medical condition. But once one ticks the
through
box,
the understanding,
yes,
it all flows from that.
it all flows from that. So if I'm right in my submission on change in medical condition, we're now on the question of materiality. And in my submission, the change is material because when one looks at the impact of the current condition by reference to NXE, LXR would be entitled to a higher award. Therefore, in my submission, it's material.
Even without the situation being, the condition being worse than
Yes.
before.
Exactly so.
Basically because you're submitting that this aspect hasn't been factored in. The mental harm.
I prefer to look at it as, to use the words of the scheme in paragraph 115, would it be unjust to maintain the original award in light of the change in medical condition and all that we know now?
Yes, but you get to that by working out how the scheme would apply if you could reopen.
Yes, exactly. Yes, that's my submission. So let me assume, for the purposes of my submission, that the change in LXR's insight into the cause of the PTSD, let's assume that that did constitute a change of LXR's medical condition. The question would then be, is the change in LXR's medical condition so material that it would be unjust not to reopen the award and make a higher award? Well, that of course is a matter for the judgment of the decision maker, here the First-tier Tribunal, not this court. But in my submission, it is at least possible that a decision maker could conclude that it would be unjust to deny LXR that higher award.
Is another way of putting that, not saying I agree with it, I just want to understand the submission. Is another way of putting it that if what the applicant now understands, according to the evidence that you've shown us, if that had been his understanding before 2019, and therefore the medical evidence that we now see had been placed before CICA at that time, is it at least possible that CICA would have given a higher award?
That's effectively, there's a more elegant, if I may say so, more elegant way of putting my submission. That's effectively what I mean. And in light of that, is it now unjust not to give that award? Now, my third point about materiality is that a change wouldn't be material unless it was directly attributable to the crime of violence. Bearing in mind that as set out at paragraph 4 of the scheme, the scheme only provides compensation for injuries directly attributable to crimes of violence. And that was a point made by the Court of Appeal in Williams, paragraph 25. And that, in my submission, is why the correction of a misdiagnosis wouldn't come within paragraph 115, because the change wouldn't be attributable to the would be attributable to the error of the original doctor rather than to the crime of violence.
Well, yes, I'm not quite sure that's exactly the way the court put it. They say, this is what Lord Justice Ward says at paragraph 25. The three separate elements. There should be a change in the applicant's medical condition, that's the first. Second, the change has to amount to a serious change, we now say material. Third, the change has to be directly attributable, and that's because of paragraph 4, but he's not saying that's part of materiality. And that indeed is the way that the FTT approached it in this case, because they say, don't they, in paragraph 45, if we are wrong about there being no material change, we go on to consider whether any material change is directly attributable to childhood sexual abuse. And they say no. And indeed, when you were addressing us on what you said medical condition was, you said in terms that the understanding was caused by the therapy. And that's what the FTT found.
Well, I'll come on to the FTT's conclusion in my submission. The FT, first of all, there's no appeal against the Upper Tribunal's conclusion in that respect. It's not before this court. Question is,
Well, the Upper Tribunal didn't deal with it.
well, there's no complaint about that. There's no ground of appeal in respect to that. But anyway, I'm going to come on to submit that the FTT erred in that respect because its conclusion on direct attributability was predicated on its view of what can and can't constitute a change of medical condition. But if I may, I'll come back to that in a moment. Well done.
Not sure about that,
well-
because they talk about understanding and so forth in paragraphs 49 and 50.
They do, but can I can deal with it now if it's troubling my
Oh,
lord.
no,
at this
it's all
stage.
right. You deal with it in your own
I am
time.
going to deal with it.
Yeah, fine.
What I'm dealing with at the moment is, can I put it this way? I accept that correction of a misdiagnosis cannot come within paragraph 115. To an extent, it doesn't matter by what route one comes to that conclusion. But what I'm respectfully submitting is that the logical way in which one screens out corrections of misdiagnosis is because that wouldn't be material to wouldn't be so material a change that it would be necessary to correct the injustice, because materiality embraces a requirement for attributability. Another way of doing it would be just simply to graft on the requirement of attributability by reference to paragraph 4 of the scheme.
So why isn't this the present case a misdiagnosis case? In the sense that doctors, for perfectly understandable reasons, it may be said, given what information and the demeanour of the applicant and so on, they're the experts. They assess someone not just on the content of what they're told, but no doubt things like demeanour and the whole person. They came to the views that they did in 2019 or before that. As a result of what you describe as the change in his understanding, doctors have now given a different diagnosis. But why isn't that a classic case of that was a misdiagnosis at the time?
Well, this diagnosis my submission connotes a mistake by the doctors, and if the doctor,
Not necessarily. It doesn't. I'm not. I don't think you have to import any kind of fault or negligence or anything like that. It's just that they came to the wrong diagnosis. As I say, for perhaps understandable reasons, given what they were themselves being told by the applicant at that time.
well, in that respect, in that respect, I would accept one could characterise it as having been the wrong diagnosis originally. When I use the expression misdiagnosis, and as I understand it, when the Court of Appeal used the expression misdiagnosis in Williams, they're talking about a mistake.
You're talking about an erroneous diagnosis which flows from the condition itself.
Exactly. Which is why,
Because of the repression.
exactly,
Characteristic of the problem.
and I got caught up wrongly, as the Upper Tribunal held, and I don't seek to question that. I got caught up with the question of whether it was reasonably ascertainable before the Upper Tribunal, but I've jettisoned that. The simpler way through this in my submission is, well, was there a material change in the condition? And change in understanding falls within the broad concept of change of condition, and that's it. Anyway, all I was doing at this stage of my submissions on materiality was to make the submission that I don't contend that an erroneous, mistaken diagnosis connoting some fault on the part of the doctor would come within paragraph 115. So, those are my submissions on paragraph 115. Paragraph 115, of course, has to be read in the context of paragraph 116. One only gets into 115 if the application has been made within 2 years of the original award, or the application can be determined without further extensive inquiries.
So if you say that that acts at least as some restriction on the possibility of the floodgates being opened.
I do. Could I then please try and pull together the threads of my submission so far and explain how we say that paragraph 115 should operate? So let's assume that the limitation period under 116 has been satisfied. If the current medical condition of the applicant would have resulted in a higher award than was originally made, if it had been apparent at that time, then providing that the applicant or his advisors or his doctors weren't responsible for that not being apparent at the time of the original award, then in those circumstances, it's liable to be unjust not to reopen the decision and to make the higher award. So effectively 2 questions for caseworkers. Question 1, is the current medical condition, would the current medical condition have resulted in a higher award than was originally made if it had been apparent at the time? If yes, was the applicant or his advisors or doctors responsible for it not being apparent? If the answer to that's no, then it's liable to be unjust not to reopen the award, in my submission. It's a fairly straightforward exercise. Finally then, in relation to the scheme, can I please ask the court to turn back to tab 3 of volume 1. And page 65. And so we're back at paragraph 89 of the scheme. if I could put a hypothetical. Suppose that a person is raped as a young child, and suppose, as sometimes occurs, that the individual completely blocks out the traumatic event. Suppose that the unblocking then happens at the age of 40. Perhaps it's triggered by another traumatic event. And suppose that the claim can be determined without further extensive inquiries. As CICA's guidance indicates, that I showed the court earlier, in those circumstances, the claims officer may well allow the claim. And if there was a permanent disabling mental illness, the claims officer would make an award under B12. Can we then please look at page 71? Paragraph 115. If I could posit a second hypothetical example. Suppose again that the person was raped as a young child. This time, suppose that the individual was conscious of the physical injury of the rape, and on that basis, when he was 20 years old, received an award for that injury. That would be an injury under B9 of the tariff. Suppose that at the age of 20, the individual wasn't aware of the traumatic psychological consequences, again because they'd been blocked out. And again, suppose that the psychological trauma becomes unblocked at the age of 40. And again, suppose that the claim can be determined without further extensive inquiries. Again, suppose that on present condition at the age of 40, there's a permanent disabling mental illness that would meet the criteria under B12. That would be what, in the case of Colfax, the Court of Appeal called the late manifestation of a new type of injury, which they said is readily accommodated in paragraph 115.
That is to say, a set of symptoms or a presentation which wasn't present before.
Yes. So that's my second hypothetical example. Now, if I may, I posit a third hypothetical example. Now, this is identical to the second example, except that the traumatic psychological consequences haven't been completely blocked out. Instead, they were transferred to a different traumatic event. I'm using the language of Dr. Scott.
Which happened in 1998. This was in the present case.
But I'm testing the scheme, testing the meaning of the scheme. In my submission, it would be anomalous if the scheme ruled out compensation for psychiatric injury in the third case on the basis that the traumatic psychological consequences were transferred rather than simply blocked. And that's the consequence of CICA's submission. In my respectful submission, this court should endeavour to avoid such an anomalous result. As I've submitted, one can do so by giving full width to the expression, the medical condition of the applicant. So those are my submissions on the meaning of the scheme, topic 2. Topic 3 then, which I can deal with quite shortly, is what we say the errors were in the First-tier Tribunal's decision. I'm going to deal with my Lord Justice Lewison's question about attribution at this stage. The First-tier Tribunal's decision is in the core bundle again, page 251. And I'd ask the court to recall page 253, paragraph 11, the finding that there was a change in LXR's understanding of his condition at its origins. And then if we look at paragraph 19, 3 lines from the end, in my submission, the tribunal directed itself that a change in understanding isn't a change in medical condition, isn't capable of being a change in medical condition. And
That's also clear from 11 itself.
yes, it is. It is. It's
The contrast they're doing rather than.
quite so. It's perhaps even clearer at the bottom of paragraph 19, but I accept my Lord's point. And that, we say, is the misdirection in law. Instead, the First-tier Tribunal seems to have thought that what was needed was a worsening of LXR symptoms. Paragraph 18, it defined a medical condition by reference to how good or bad the individual's physical state is. And then paragraphs 22 right through to 44, what the tribunal does is examine the evidence in relation to LXR symptoms and concludes that there was insufficient evidence to show a worsening of his symptoms. Now, as I've indicated, I don't challenge that finding. Rather, we challenge the conclusion, the legal conclusion, that the change in understanding identified by Dr. Laws is incapable of constituting a change in LXR's medical condition. Can I then please deal with what the tribunal said about whether the change in medical condition was attributable to the childhood rape? I make the first point, which I've already touched on earlier, that there is no appeal against the Upper Tribunal's decision on the ground that it failed to deal with attributability. So in my submission, this issue is just not before this court. With that said, could we then please look at page 259, paragraph 50? And what the tribunal said was, in our view, it's clear from this evidence that the material change isn't directly attributable to the crime of violence, i.e. the childhood sexual assault, but rather to a change in his own understanding of the cause of his psychological problems. Now, in my submission, that conclusion on attribution is on the hypothesis that the unblocking of the relationship between the trauma and psychological distress isn't a material change.
Sorry, say that again? This is on the premise that the unblocking is not a material change?
Yes, because that's, in my submission, one can't make sense of the sentence I've just read otherwise. It's clear from the evidence that the material change isn't directly attributable to the crime of violence, but rather it's attributable to a change in his own understanding of the cause of his psychological problems. But it's his change in understanding that, in my submission, constituted the material change in medical condition. And the problem with this is that the tribunal simply didn't determine whether, if the change in understanding was a material change, whether that was directly attributable to the rape.
There's only one answer that can be given to that question.
Well, in my submission, the answer is crystal clear, that it is obvious that the change in understanding was directly attributable to the rape, because the change in understanding was the direct result of treatment. The treatment was a direct response to psychological symptoms. The psychological symptoms were the direct consequence of the rape. There's a direct and unbroken line of
I
causation.
can see that that would be indirect attributability. I'm afraid, speaking for myself, I cannot see how that can be described as direct attributability.
Because there's no supervening cause.
Well, paragraph 49 itself says it is because of the report of Dr. Scott and other developments, including subsequent work, that his understanding has changed. That's what they're getting at paragraph 50.
Report and treatment.
Yeah.
Yes. But
And that's the way you put it, as I suggested to you earlier. That's exactly the way you put it in your oral submissions.
not what they're saying in paragraph 50 in my submission. But anyway, if there's even if there's a problem with the Upper Tribunal's judgment, in that the Upper Tribunal should have confronted the question of direct attribution but didn't do so, it's not a ground of appeal.
No, I
it's
understand
not before
that.
this court.
This argument involves treating the change in understanding as a freestanding material change.
But it has consequences in respect to treatability.
So it's something which I said call it freestanding because you say it should have been separately assessed.
Yes.
Can I just ask you, given that I think one of the points you've made in response to round 1 of the CICA appeal is that there is no universal rule that a court cannot raise points of its own motion, if they're points of law. Right? Can I raise one possible way that you may have a difficulty, even if we agreed with everything you've said so far? There's no appeal, as you say, by CICA against the failure by the Upper Tribunal to address the direct attributability point, which on the face of its judgment, the FTT was saying is a knockout blow, even if they're wrong about the meaning of vertical condition. Suppose we were to reach the conclusion that you're right about what you've said so far, but it's perfectly obvious to us what the outcome would be. Given that this is a judicial review case, it would have to be remitted, presumably, to the FTT.
Yes, who make a new findings of facts ab initio.
Well, maybe, but let's just say that we took the view that Section 31 of the Senior Courts Act does have some role to play. I know you've said they haven't raised it, but why can't we raise it if we thought that might be the answer? And it's perfectly obvious what the answer is going to be. That if we took the view that you cannot get home on direct attributability as opposed to indirect attributability.
My submission on that, my primary submission in response to that would be, it is not so obvious. The question of direct attribution is a fact-sensitive matter of evaluation and judgment for the primary decision maker who's charged with making this decision. It's not a primary question for this court. And in circumstances where in my submission the tribunal has made an error of failing to confront the relevant material change of medical condition, it can't be said to be highly likely that if it had directed itself correctly on that issue, it would inevitably have reached a conclusion against the applicant on direct attributability.
Mr. Butler, I certainly don't want to impose on you. If you want to think about it further and perhaps even put something on the side of A4 for us, because as you say, it's not a point that's been raised against you to date. But it's just occurred to me in the light of the submission you just made to us.
Thank you. I'll take up that invitation if I may. Reflect on that and provide something in writing.
It may be a bad point. It may be that it's not right for us to take it, but it's in my mind, so I thought I would raise it with you.
Thank you.
You might like to reconsider what Dr. Law says on page 205 of the supplementary bundle, first and fourth paragraph on the page, which starts with, since LXR and I have been working together. Which is, I think, where the FTT got their view from. And it's the therapy that's been the cause of the change in the understanding.
Yes, well, my submission has been it's the therapy that caused the change in understanding.
Yeah.
But the submission I would make to the first-tier tribunal in the event of remission is that that's direct attribution. I mean, if one looks, I mean, I'll have to reflect on this and make more fuller submissions. But if one looks at the approach to direct attribution in the case of Williams, in my submission, we fall squarely within the concept of direct attribution.
Could I ask a question, please, about Dr. Law's letter, because your argument rests on this, as I understand it. You took us very carefully to pages 204 and 205. Stop halfway down 205.
Yes.
Can we go to 206 to summarise this her opinion? She says there are two aspects of the material changing condition. One of these is his own understanding as the cause of his mental health condition, which has changed. He now understands that, etc., etc. The other, so there are two aspects of what she describes as one material change. And I ask about that because although you might say, well, we shouldn't really look at it, it is in the bundle, tab 32. Further report, which I think we were shown this morning on behalf of the appellant.
Yes.
The letter of the 26th of July 2023, which is just after the FTT decision, I think, and 2/3 of the way down the page. Point 1, the change in X's understanding of the cause of his symptoms is a change in his medical condition due to the fact that this change in it led to a change in symptomatology. So in other words, it's linked to symptoms. These two aspects end up in her second go as symptom related.
I accept, my lord. If this court were dealing with, were making factual findings in light of all of the evidence that's now available, that would potentially be a difficulty that I would have to confront. But
Forgive me for interrupting, but it may be implicit in page 206.
well, in my submission, that is reading.
Two aspects of one material change.
Well, I have been quite careful to found my case on the findings of fact that were made by the First-tier Tribunal.
Well, that leads with respect to my other question from earlier on. It's just how was the appellant's case put to the FTT?
Well,
Was this separate freestanding strand actually put for them to rule upon?
well, it's if one looks at the written submissions, which is all that we've got,
Yes.
there is a distinction drawn between change in understanding and symptomology. They're two discrete points. And well,
Have we looked at that?
you were shown it by Mr. Morasso.
I might need to look at it again.
Sorry, I think it's page C202. I think.
3.
C, core bundle 202.
Thank you very much. Sorry, it's my fault.
It was 302, C302.
Well, I'm not sure you're right about this, Mr. Butler. Paragraph 35, it is quite true, is headed the appellant's own clinically significant understanding of his condition. But the reason given in the second sentence of that paragraph is that this is a significant change in the appellant's condition because of its symptomatic consequences.
That I accept. Last sentence, indeed, whereas the evidence set out below shows much of diagnostic work in psychiatric injuries relies on the patient's own report of their symptoms and understanding of their traumas, a change in such understanding is of itself part of one's medical condition. That's the submission that was made.
Yeah, part of.
Yes, part of one's medical condition, of itself. And that's what the tribunal finds as fact, that there has been a change in that understanding. But they say that cannot be part of medical condition, and it's in that respect that I say they were wrong. And to come back to my Lord Justice Holgate's point about the report that was in front of the tribunal, I accept that, of course, Dr. Law is talking about two aspects of the condition
Of the material change.
of the material change. But the tribunal very clearly separate the two out and say that the one aspect can, the one aspect can't form part of a medical condition.
Well, then, alternatively, that's a question of reading it again as a whole, but they might have just been looking, was it paragraph 19? Was that perhaps just a staged on the way to their overall conclusion, as opposed to treating it as a freestanding issue?
Well, paragraph 11, they make the finding of fact,
Yes,
and then they rule it out as being relevant to change of medical conditions. That in my submission is the error. I accept that there may very well be a lively debate on remission to the First-tier Tribunal of what precisely one should conclude in respect of the evidence, both in terms of change of medical condition and in terms of attributability. But that's not this court. We're dealing with the question of whether the Upper Tribunal committed an error in concluding that the First-tier Tribunal had misdirected itself on medical conditions. That's it.
You've shown us paragraph 11 of the FTT several times, but it's showing that they accepted that there was a change in understanding. But the full finding, of course, is that it was the treatment itself which led to the change in understanding. That's the finding they actually make.
Yeah. Yeah, you do. I accept that. And I just take my law puts emphasis on that because of what it might be said to indicate about direct attributability.
Exactly.
But at the moment, I'm dealing with the Upper Tribunal's conclusion, whether the Upper Tribunal was correct to say that there had been a misdirection on medical condition, and I've made my submission as to why that's the case. There is a separate question about direct attributability, which isn't at the moment part of this appeal, but I'm going to reflect on what my Lord Justice Singh observed about that and consider whether or not we want to make further submissions on whether this court might properly dismiss the appeal on a section 31(2)(a) type basis.
Just on this may be a technical point. Section 31(2)(a) applies to the Upper Tribunal because of something in the 2007 Act by way of amendment. Is that right?
I think that's right.
That's my recollection.
I'm sure we'll reach an agreed position on that.
Yes, that's right. I think it's section 15 of the.
That's right. That's what I remember seeing.
Right, well, I've made my submissions as far as I can on direct attributability, albeit reserving some of it, if I may.
Yeah.
Could I then deal with topic 4 and the grounds of appeal? The submissions I've made so far have addressed ground 3, the interpretation of paragraph 115. On ground 2, I simply say that if the First-tier Tribunal misdirected itself on paragraph 115 of the scheme in the way that I've identified, well, that was an error of law. On ground 1, my submission is that LXR pleaded that the First-tier Tribunal misapplied paragraph 115 of the scheme. At least to an extent, that put into issue the proper interpretation of paragraph 115. In response, the Upper Tribunal interpreted paragraph 115 and concluded both that the First-tier Tribunal was wrong in its interpretation and that I was wrong in the interpretation I advanced. And on this appeal, I've accepted that the Upper Tribunal was right to say that my submission was wrong. In my submission, the Upper Tribunal was entitled, indeed was required, to interpret paragraph 115 for itself, because this wasn't a private law claim concerning only 2 competing private interests. It was a public law claim in which the public interest was also at stake.
Well, that's no doubt right. And in fact, even in a private contract case, the court is not bound to choose either of the interpretations put forward by the parties. But I think Mr. Moretto's point is that it shouldn't spring fully armed like Athena from Zeus's head in the decision. It should be put to somebody so they can deal with it before the decision comes out. That's the real complaint.
Yes. I'm going to address that, if I may, in a moment. Could I just show the court one authority on this? And that's the Divisional Court's judgment in a case called Johnson, which is Authority Volume 2, tab 39.
I think this went on appeal to the Court of Appeal, which I think dismissed the appeal, but on
grounds.
somewhat different grounds.
I think they said that it's quite an unusual finding that the legislation was irrational. Disagreed with the Divisional Court on statutory interpretation, but nothing turns on that. So, my Lord Justice Singh will be very familiar with this judgment.
Sorry, can I just have the reference?
Yes, sorry, it's tab 39, it begins at page 1108. And so this was a case about universal credit and the problem of the DWP treating 2 months' worth of salary being received during a single assessment period. And if we could look, please, at page 1119. If one looks at paragraphs 39 and 40, one sees that the claimants pleaded that the regulations in question were ultra vires or contrary to Article 14 ECHR. But then, as the court identified at paragraph 40, the logically prior question was what was the proper interpretation of the regulations? And that hadn't formed any part of the pleaded case. The court then rejected the pleaded case and instead allowed the claim on the basis that the Secretary of State and the claimants had misinterpreted the regulations. And that conclusion is recorded at page 1125, paragraph 62.
Yes, my recollection, but I'll stand corrected if I'm wrong, is that this was raised by the court for the parties during the hearing, and they had the opportunity to make submissions, and my recollection is no one said we haven't had enough time to make submissions. So the procedural irregularity point didn't rise, I think.
At the moment, I'm not trying to meet the procedural irregularity point here. I'm just saying that as a matter of principle, it's permissible for a court to reject
A classic example of this was in 1992, the House of Lords, when it first heard Pepper and Hart. It was a 5-judge panel. They went away and did their own research on Hansard and were troubled by what they read and wrote to the parties to say, we're going to reconvene this on a ground that no one's raised before us, but we think it's very important that we consider the admissibility of Hansard.
Yes.
And we all know what then happened.
In my submission, it may have been preferable had the Upper Tribunal taken such an explicit approach and said, I'm minded to reject the interpretation advanced by both parties. I'm contemplating interpreting paragraph 115 in the following way. Does anyone want to say anything about it? Clearly, that would have been a preferable course. But in my submission, the Upper Tribunal didn't act so irregularly that it would constitute a procedural unfairness, because the point was at least put during the course of oral argument. And can I show the court the references to that? So, supplementary bundle page 285. Lines 25 to 33. So that was during my opening submissions. And then page 313. This is during Mr. Moretto's submissions, lines 5 through to 9.
I'm sorry, Mr. Butler, I'm behind you. What was the second page reference?
Page 313, lines 5 to 9, during Mr. Moretto's submissions. And then the final reference.
Sorry, what is the judge saying that's relevant to this point?
There was he's suggesting that there was a difference in the applicant's understanding and that was capable of constituting a change in medical condition. The following page, page 314, one gets a bit more from this, lines 4 through to 19.
Sorry, lines
4 through to 19.
This again is tied to Dr. Scott's report. But if we're looking for something which ends up as, is it paragraph 29 of the Upper Tribunal's decision, with that list of factors, including etiology, for example, I don't think we see anything like that in the discussion.
No, but that's not the central part of the, that's exposition rather than the conclusion. The conclusion is that it's a broad and undefined expression, which is wide enough to embrace the thing that was excluded by the First-tier Tribunal. And in my submission, the judge did at least suggest that one could simply read the expression in a broad way.
Yeah.
It's worth also in my submission considering what success on ground one of the appeal might look like. Because ordinarily, in the event of a finding of procedural irregularity of that kind, the case would be remitted to the Upper Tribunal so that it could be dealt with fairly. But in my submission, that would be artificial, given that this court has or will have heard full argument on the point of law that it's now said should have been put more squarely, namely the proper interpretation of paragraph 115. So in my respectful submission, ground one really doesn't go anywhere unless CICA is arguing that this court shouldn't deal with the question of proper interpretation of paragraph 115 and should simply remit to the Upper Tribunal for a fair consideration. There is also, as an alternative, our application to amend the grounds of claim so as to incorporate the Upper Tribunal's approach. I don't seek to press that point. It gives this court another option.
Yeah.
If it were attractive.
Can we do that at this late stage of the proceedings? You want to re-amend your statement of facts and ground in the claim for judicial review?
That's the suggestion.
Are you making that application or not?
Well, the application is before the court. I don't withdraw it, but it's very much a tail-end point in the event that the court has rejected my submissions on ground one in their entirety.
Yeah.
So those are my submissions on the appellant's notice. Unless the court has any further questions relating to that, I then have my Article 14 points.
Any questions? No. Thank you very much.
I don't know whether my lord.
Well, would you
I think
like
I've
a
got
clean start in the morning?
Yes,
We will presumably finish in the course of the morning.
yes. I'm confident we will.
Yes, I think we're finishing the course of the day. I think we were.
Course of the
time-
day. You're down for a day and a half, I
Yes,
think.
sorry, I thought, my lord, you said in the course of a day.
No,
So
in
the
the
answer was
course of the
definitely in
morning.
the course of a day, but I think we should finish within the course of half a day, yes.
Right. Good. All right. 10:30 tomorrow.
All rise if able.